So I only used 13.
Yeah, of course. That's what he
But I also want to
It's this one.
I do, yeah, I guess I'm going to have to read it.
all the stuff that we were concerned about.
I believe we're ready.
Yes. So which pages are we?
This it's at the very
It's the last like 9 pages or 10.
no, but it's actually a lot of. It's like the last 30.
This is a proposal to change how we review our plats and to bring the Planning Commission into the process. Now, having said that, currently newly proposed subdivisions are submitted to the city as a concept plan that is reviewed for compliance with city codes by the community development staff before being presented at a public informational meeting. Subsequently, land disturbance plans are submitted and reviewed before a permit is issued and the development is constructed. The applicant must then file a final plat, and that is reviewed by staff and approved by the mayor and city council before being recorded at the Fulton County Superior Court. The purpose of this text amendment is to require applicants to submit a preliminary plat, formally called a concept plan, which is reviewed by the community development staff for completeness, and then presented at a planning commission meeting where the subdivision will be either approved or denied. The text amendment would then also require that following the issuance of a land disturbance permit, a final plat be submitted by the applicant that would be reviewed by staff and certified for compliance by the community development director before being forwarded to the mayor and city council for a public hearing and confirmation. Upon confirmation, the city will record the final plat at the Fulton County Superior Court. So what we are doing is we are proposing that the Planning Commission be brought into the process. And if you look at the little diagram that we've put together, we show the two-part process. The first is the preliminary plat, which is a new process, and then the final plat basically follows along with what we're currently doing as it relates to the city council. But at the preliminary plat process, the preliminary plat will come through the staff to the community development department, and we'll review the application for completeness. And then it's then forwarded to me as the community development director. And then depending on the size of the plat, if it's a minor preliminary plat of 3 lots or less, I will approve that plat. If it's more than 3 lots, it will be handled as a major preliminary plat, and it will be forwarded to you, the Planning Commission, for your consideration. Once it comes to you, you will hold a public hearing on it, and you will have the ability to either approve or deny the plat. Then, assuming it gets approved, it will then go through the land disturbance process, and then at that point, it will come back to us for a final plat review and approval. And that essentially includes, again, coming to through the...
Us being you, or I mean, staff or planning.
I'm sorry, where are you now when you said us?
You just said us.
Oh, okay. Well, the first box on the left for the final plat review is the community development staff.
Okay, you.
Me,
Okay.
that's right. So we will review the application for completeness, and once it's complete, I will certify that the plat is in compliance with the city codes, and then we forward it to the mayor and city council. And this is essentially the same process we have now. If it's a minor plat, it gets put on the consent agenda for their confirmation. If it's a final plat, which is a major plat, it will be put on the council agenda under new business, which allows the council the opportunity to discuss it. Now, if something's on the consent agenda, the council always has the ability to pull it off consent into new business. But our usual process, if it's a minor plat or less, it will just go on the consent agenda. And then if it's above 3 lots, it will go on for under new business, and we usually give a presentation and explain it. So that's the process that we would like. We felt that by allowing for a public hearing in the early parts of the plat process, by the Planning Commission. It gives the community the opportunity to ask questions. We'll have the developer here, and you all can certainly ask questions from the developer, of course. And it will allow the community that opportunity for input. And then, of course, you will have the ability to approve or deny or request modifications and then deferrals and whatnot through the process.
Kathy, that public hearing will take place during a regularly scheduled.
Yes, just as we had for the rezoning, where you have a public hearing.
How often, how many, and based on what you've experienced, say, in the last year, how many of those would come before us if we had this process in the last year, do you think?
4 or 5 or so?
I think we've had, with this the old process, there were 2.
But in the last year, if we went back to a year, yes, maybe there were
4 or 5.
Yeah, not a
Not an
lot.
unreasonable number where
Yeah,
if we've got other things on our agenda, it's not going to.
I don't think it's going to overwhelm you at all.
Probably similar number of items that we used to have form-based code. I mean, we used to have a lot of rezoning, so I think.
My only concern would be on the property at Brookshade, on the other side of Brookshade, where you have 70 or 80 people here that had signed the petition. How long are we going to give them then to speak?
Well, I think if that parcel, Mr. Sue's parcel, came in, it would only come in as an AG1, so they wouldn't be opposed to it. This isn't for rezoning. This isn't preliminary plats
It's just
per se that would
finding
go
a
through a rezoning. Let's say if this Mr. Reese's came through,
Right.
it wouldn't go as a preliminary plat. It's already done as a rezoning and the concept plan. So yeah, so it'd really only be AG1.
Actually, it gives it more light of day than it might if it were just like a CZIM, not CZIM, what's the information meeting?
Yeah, that's correct. I mean, it was a public information meeting. Yes.
Exactly.
Gives it more of the light of day to the community that may have otherwise been less engaged.
Yeah, and, and because we've heard from the public that, people will be driving down a road and all of a sudden there aren't any trees anymore. And they're like, well, what's going on here? And so, the opportunity here is to be able to give the community the chance to see what's going on, to ask questions and whatnot.
I had some points on it, too. Yeah.
Kathy, on page 6, under section 50-44, where it says preliminary plat required, in the blue, which I assume, those are the additions, it's the second to last, or maybe it's the last sentence, says approval of the preliminary plat application shall be considered by the director or the planning commission as appropriate. What would determine the as appropriate in that particular segment?
I think it's minor or major.
Yeah, that's exactly right. If it's a minor, I get to review and approve it.
Okay.
And if it's a major, it comes to the planning commission.
Okay, great.
Next page, section 5049. Reading that, it don't seem to work out. In residential subdivisions, building permits may be issued on the basis of after the approval of. That
Well, I think it's supposed to be.
doesn't
It would remain as in residential subdivisions, building permits may be issued on the basis of any approved minor plat or final plat, only after the approval of the mayor and city council's confirmation.
only in there.
So the light blue we added, and then the strikeout we took out, so.
Yeah. It is only,
I mean, basically,
only is there, Fred?
yeah.
Basis of.
So we can't issue a building permit until a final plat or a minor plat is issued, so.
Where you highlighted it in blue, I was taking that out instead.
No,
of
that should be
my-
included. It was just a
my error.
comment from
My
the
error.
city attorney. so-
Sorry.
Yeah, so it's a two-part process that, the planning commission or myself as community development director have to approve the preliminary, and then the final has to be confirmed by the city council. That's state law. And at that point, then the building permits can be issued.
Would we get more, like we get the plats now, would we get like a topography map or something a little bit more than just a plat itself? Or would we get a little bit more to be able to visualize it and see it? Or would it just be, just something like this?
Actually, that has topo on it, but I mean, a plat typically does not have.
Okay.
Well, the preliminary plat may have the topography on it. A final
Sometimes like
plat,
the, like the color, the Google, like what it looks like,
I mean, if that's something you want in the report, we'd be happy to do that.
that's something we'd
That's
want to
fine.
kind of see what, an actual over aerial picture maybe.
Yeah, and, and as we start to go through this process, if you want to add any other requirements, we can certainly do that as well. But we can add the topo right now, certainly. Yeah.
Already got something before page 11?
No.
On page 11, under the blue section under E, I'll make sure I understood that correctly. For all final plats, after staff determination that the application is complete and signed accordingly? Or does that mean like signed and stamped?
Signed, I think it should be
Yes.
signed, ED.
Okay.
I did have that down, Paul. You're right.
Oh, good. I'm on the Fred wagon. On page 12, when it talks about the process, the sequence of events that take place, obviously if the Planning Commission approves it, it makes sense that it goes forward per the described process. If there's a denial by the Planning Commission, is there an appeal before it goes to the next step?
Yes, and what is that, Robin? Is it the court?
No, if the planning commission denies it, I
Denies.
believe it goes to the city
Still
council.
goes to the mayor and council,
Yeah.
with just our recommendation for a denial, just like a variance would.
Right.
So it is a so we do have
It's an actual
denial.
Not
yeah.
a recommendation, it's a denial.
Oh, okay.
Because I'm going
I
to
mean,
give
that's-
you, later on tonight, the power, I'm going to recommend that you get the power to
Okay.
actually be able to confirm or deny.
Okay.
And I want to better understand that. That was my concern. So if we do deny it, the process stops, or it goes forward to the mayor and council with a recommendation for denial.
Well, it says here, and on page 10, under the preliminary plat, said, should the preliminary plat application be denied, the basis for the denial shall be stated in writing to the applicant. The subdivider may file an appeal in accordance with section 5231, which I believe is the variant. I mean, it's to the, I need to look that up.
Yeah, but then, so
Because that's from the subdivision reg, so it's, I
what
need to,
happens to the appeal? Where does that go?
I believe it's to the council.
yeah, I believe it's to the council.
The applicant has to make that appeal. It doesn't automatically get appealed. You deny it, so it stops until such time as the applicant.
And that subdivider may file an appeal, yes.
It's a little confusing, I mean, maybe to me, but on page 9, it says if the plat is denied without prejudice, they can come back and revise it and resubmit it. So is that, I guess that's different than an appeal? An appeal would be keep it exactly the
Right, so
way
if
it
they
is.
chose, like, okay, I'll go ahead and go back and fix it the way that you want it, that's what that speaks to.
Well, no, I think you deny it, and then they can bring it back.
And
But
then
it's-
they can bring it
But it
back.
sounds like we can only say yes or no. It doesn't sound like we can make conditions, or it's a yes or no answer from us, the way this is written.
I mean,
So how
we
do
have-
we,
Yeah.
you know what I'm saying? How do they have to come back, kind of read our minds and say, okay, here's what I think they maybe meant, because we're not really making recommendations.
Could make recommendations during saying we denied it because of, and you give them the reasons for that and things to consider.
They can decide if they want to,
They may or may not decide to do that.
they can appeal it, or they can fix it and bring it back, I guess, in the next month. Because there's no time, like some things, if you deny something, you have 6 months, but
right.
they could bring it back the next month and then the next
Bring it
month.
back, yeah.
Okay.
And try to respond to your concerns.
Okay.
Or they could just appeal directly to the city council.
So that makes more sense to me. If we approve it, obviously it goes through. flying colors, no delays. If we deny it and they come back with an adjustment, it comes back to us on whatever, and it may very well be 30 days later with the chance to adjust those things. But if we deny it and they choose to appeal, does it then skip us and go to the mayor and council for consideration with
The way it's written, the
Yes, I believe it. Yeah,
appeal
once
goes to
you,
the city
yeah.
council, but then the applicant would then have to explain to the city council, why they didn't address your concerns. I mean, so I think it would be a matter of strategy from the applicant's point of view.
So let me ask you, so that section that's referenced 50
I'm looking it up right now, so.
Yeah, so it's on the last page, page 31. And that section references director, should the director deny? So do we need to have any reference to planning commission denial?
Let's see.
There,
What page is that?
Last page, 31.
but it's also somewhere else in between that too, because I had that same question.
Okay.
Instead of wherever else it is, it says to the director, it doesn't say to, it says to the director of planning commission, not the planning commission.
Is that what the,
Where are you looking at on page 31?
page 31, that section 50-231?
Well, they mean, the director means not to the planning commission, but director of community development. Should the director deny any such plat, minor or final, a written explanation shall be provided stating the basis for the denial. So this is speaking to final plats, not to the preliminary plat that you have jurisdiction over. So let me see what the, that 30 or 50 dash, yeah.
This preliminary plat, and then it references filing an appeal to reference section 50-231. And then 231 should reference preliminary plats as well.
The one on 31, no, that only speaks to the final plat after the preliminary plat is being done.
So what I'm saying is that section 50-91 is about preliminary plats, right? Section 50-91.
Right, correct, yes.
And if there is a denial by us, planning commission, for that preliminary plat,
It goes 50-231.
right?
That's what we're
so
trying
if
to
it goes to 50-231, should 50-231 then reference the denial from the planning commission on a preliminary plat? Because right now it just says, should the director deny? And it's referencing just director and not planning commission denying a preliminary plat and then the appeal process.
Same thing in 50-232.
Yeah, it's in there twice.
So 50-231,
It's right in the next section. Very last page.
okay, so I see, well, obviously, I'm sorry, 50-231 does reference back to page 31. It's nothing, and so we're just keeping it the same, the denial appeal process, should the director deny any such plat, but it's saying it's the same appeal process for the preliminary plat, so I apologize if I confused. So on page 10, it refers to, in accordance, shall file an appeal in accordance with section 50-231. So if we go to 50-231, well, what happens if there's a denial? Then it says that it's, instead of being the director denying it, it's really you guys denying it and saying
Right.
within 30 days of the date,
That's what,
then they should do all those things, which actually
Have
includes.
a reference in there about planning commission denying it
Right.
versus a director denying it.
It's the same.
Well, I can ask the city attorney when it goes, the blue is from the city attorney, so I can ask him just to clarify that. That's fine. I don't want to.
Same thing in 50-232A,
on 31.
also on page 31.
Right.
Both of those refer back to the director rather than to the planning.
So we'll get that.
So if we do deny and somebody appeals, just like this procedure says in 50-231, are we providing any sort of written explanation?
So what it says when you're evaluating it on page 9, it talks about the plan on 50-91A2 says the Planning Commission shall review the preliminary plat at its next regularly scheduled meeting and shall approve the plat unless the plat is inconsistent with any specific adopted plans or policies or is inconsistent with the public health, safety, and welfare. So I think it would probably be a process where you might want to write your statements of the reason why it should be denied, because in reality, when we present a preliminary plat, it should meet all the codes and regulations. So you can't really say, oh, it's not meeting XYZ code in Chapter 50 or the zoning code. So you're going to have to look at, is it inconsistent with any specific adopted plans or policies or inconsistent with the public health safety? So it's really pretty narrow. Hopefully you wouldn't be denying very many plats, because hopefully it's going to be consistent with all of our ordinances.
They've already made measure of a lot of those things before they could even bring it to.
Right, it's
Well, one example would probably be that question on the sewer.
But then
Would
from
be
a-
where we'd have to say why we denied it. I mean,
Right, so then like from our procedural standpoint, like if we were to deny, like how would we go about drafting up this written explanation? Like how soon do we need to provide this to you all, or, how do we need to handle that?
I mean, I don't think it has to be long. I mean, I think when you make a statement, if you made a motion for denial, you would say, these are the reasons why we are recommending denial, and then we would just verbatim write them down or whatever. I mean, we can come up with a process, so.
So then you all would basically.
We would transmit it forward, yes.
That's basically what the applicant can go by in their appeal.
Right.
Because now they've got 30 days. So basically, if the written explanation came on the same night that we were to potentially deny it, then their 30-day clock would start at that point.
Right.
If they choose to do an appeal, or they can go back and just.
Fix it. I mean,
Reapply.
Yeah, go back and.
and you could say, well, we would really, can you please go back? Let's say the intent is to preserve, trees, more trees. It could be, okay, can you go and tweak this lot or fix this? And if you can save more trees and they go back and revise it, then you can come back and approve it. So.
one, and it has, I made a note on it. It's on page 23. It talks about sidewalks. And did we ever make any decisions or movie as to, I know all the plans say, sidewalks on both sides. Then we had discussion at one point where we said, well, one would be okay, but even though it calls for two, and then we got to discussing that maybe some don't even want any sidewalks. Where do we stand on that? Are we standing firm still on the fact, that's why I asked the question tonight of Scott,
So in the subdivision regulation, well, actually it's in sidewalks, streets, and other places, there's very specific requirements of whether it's going to be on both sides or one side. There's different thresholds. Now, I'd have to look up to see if there was an appeal process with maybe administratively to say, hey, this is my reasons for not doing it.
Okay.
That kind of thing. So, yeah. But there is a threshold, there's a guidance of what dictates whether one or both sides.
If it's location, how it deals with the Milton trails and.
That's right.
Yeah, that's what,
Some of those.
yeah.
Exactly right. And
Right.
we charge impact fees for trails, so now the developer really can't put the trails in. We, the city, must put the trails in because otherwise you're double charging. So, so all that goes into that, and that's part of our review process. Looking at what the regulations are, what the impact fees say in regard to trails. Is there a trail on this site? So all that has to be reviewed by us before we bring it forward to you.
So are we supposed to be voting on this tonight?
Yes.
Are we voting on it with some of the things that we've suggested that have to be measured by council, or not by council, but by legal?
Well, it's going to be, I'll have the legal look at it again prior to see what needs to be tweaked, if anything, and then it'll go on to the council.
Funny question to me, but are we really allowed to vote on the fact that we're granting ourselves the power to do this stuff? Shouldn't it really be granted by mayor and council?
And it ultimately will be. It will be about, once you say, yes, we agree with
Hey,
this.
we want to do
it's-
this, but
Right, and it's just like anything else.
We're going to do.
we vote for ourselves to be able to do it.
No, and they're going to have to
Council
approve it if for
wants to
some,
know that you're comfortable doing this.
Yeah.
So it's
I
important
mean-
that I think you do that.
so they're going to review it unless, they have to approve it or deny it. So maybe they'll say, we don't like this process, staff, go figure something else out, I'm not saying that would happen. I'm just saying it's their choice.
Public comment?
Yes. We do have Laura Bentley.
Laura Bentley, 2500 Bethany Church Road. So this came, and I commend staff for these changes. This all came about with Nix Road, Hopewell, some of the issues with the platting process. And
Yeah. And I think it even came before that, trying to get it out to the public and process.
So, the land disturbance permit was issued, and there were still questions, and with at least Nix Road that I'm aware of, and I know that the platting process, when it came to council, it was on a consent agenda that they were unaware. So I totally support this change in process and would very much like to see you all be involved. Thank you.
Okay, I don't have any more comments.
Don't even worry.
Okay, I'll stop it. And then we will
Okay.
Somebody's got to get a better setup for that.
No one.
have to be in
No one's here.
angle.
Any other questions for staff on this? All right, let's open up for a motion.
I move we approve the text amendment to amend Chapter 50 of the City Code subdivisions, considerations to amend the process of plat procedures as presented by staff with the considerations that we've asked them to present to legal counsel.
I'll second.
All right, any discussion on the motion? All in favor, say aye. Aye. Oppose? All right.
Okay, the next is going to be RZ 17-03, consideration to amend section 64-418, pre-development notification and public informational meeting, and section 64-419, definitions of the AG1 agricultural zoning district.
And we're also going to add all the others we'd like to add for discussion purposes, RZ 17-04, which is the R1 residential district, RZ 1705, which is the R2, and then RZ 1706, which is the R2A, because essentially what we would like to do for all of these zoning districts is to modify them as follows. The purpose of these text amendments is to delete the required pre-development notification and public informational meeting that is currently required after a concept plan is submitted for a proposed development. In lieu of this process, staff is proposing the public hearing before the Planning Commission to consider preliminary plats more than 3 lots. And this is what we just discussed. So I wanted to make sure we had the discussion on putting a new process in place before we recommended deleting the old process. And so essentially this is a request to delete the old process, which is that the Community Development Department currently is holding a public hearing on these plats before they go to the City Council, again, with the idea of notifying the public in terms of what is going on. But we feel that the process that we've just discussed with you is a better, more structured way of reviewing these plats as they move forward. So we would recommend that all of these from 03 through 06 be deleted.
You'll have to vote them on separately, but
Does we're still required, the city's still required to post a sign on the things that are, oh no, we don't, on the plats.
well, we will for the preliminary plat, so that'll remain the same. We'll have advertising just like we do for rezoning. We'll have a sign for the preliminary plat. So that's how the people know to come to the Planning Commission.
Okay, that's what I want to confirm, that still stays in place, none of that changes.
All right, any other questions for staff? So let's do a motion for RZ 17-03.
I move we approve RZ 17-03 AG1.
Second?
All right, all in favor, say aye.
Aye.
Oppose? All right, let's do RZ 1704.
Just keep going. RZ, RZ 17-04R1 for approval.
I'll second that.
All in favor, say aye.
Aye.
Aye. Oppose?
I move we approve RZ 17-05R2.
I'll second that.
All in favor, say aye.
Aye.
Oppose?
I move we approve RZ 17-06R-2A.
I'll second that.
All right, all in favor, say aye.
Aye.
Oppose? You can say,
Yeah, I'm sorry.
you can say it in the next one. Okay. Okay.
Okay.
Okay.
So the next item is Chapter 2 of the City Code Administration, Section 2-206, Duties of the Planning Commission.
Okay. Currently, the Planning Commission's duties include only the ability to review and advise on rezonings, use permits, concurrent variances, and text amendments. This proposed amendment will grant the Planning Commission the ability to approve or disapprove preliminary plats. And this is part of the global change, the preliminary plat process, which we just discussed. But this is what gives you the ability to confirm or deny.
All right. It's just that one sentence.
I only have one question. In this section 2-209, reimbursement, City Council shall only approve for reimbursement for actual and necessary expenses. And I was somewhere either led to believe that there was going to be a reimbursement to each member of the Planning Commission. Have I been misled?
No, you're right, a stipend for each meeting of $50, I believe. And I believe.
We can have this edited. Thank
Yeah,
you for that.
This
Yeah.
is inconsistent now
Yeah.
with.
So I would suggest we do change that. Do you need a motion for that?
Yes.
Reimbursement would be, I spent my money and I
Right. No, we'll fix it. We had to do it. You'll see it for the historic preservation. So we'll. use the same
That's where
wording.
I was
Yeah.
coming from.
So we'll do it accordingly, but I appreciate that. Yeah.
Okay. So you don't need an amendment? You'll just
When you make your motion, just say that as per staff, and then
make
with
a
the
motion per staff
Except-
regarding section 2-209 reimbursement.
Well, I meant to say to make it so it's allowed to have, amend it to be, what I meant was to recommend approval as presented with the exception of reimbursement to be corrected or something.
No, I didn't.
We get it. Just make a motion and to say,
Oh, okay.
Make that recommendation.
I'll make a motion to approve,
Can I just say?
yes, excuse me.
In the one sentence says, in addition, the commission is charged with making decisions on preliminary plats. Shouldn't it maybe say decisions and recommendations? Because to me,
no, you're actually making decisions.
but
It's not a rec-
to me, a decision is limited to a yes or no. I go back to that. This in the narrow scope, it doesn't allow us possibly to make a recommendation.
If it says and recommendations,
Where
decisions and recommendations.
sort of making decisions on preliminary.
Oh, you're looking on the second. I'm looking on the first one. Sorry, I was looking on.
I'm looking on the duties.
Yeah, the purpose.
Oh,
You're
okay.
saying purpose.
Yeah.
And making.
So I
finding-
just think this could be taken not very narrowly, that we don't have input, and we just have to say yes or no.
Well, I think in anything, it's kind of thought, whether it's, let's say if it's approval, that you already have the ability to make recommendations.
Okay.
Fine, but if you'd like to put the word decisions, including recommendations, would you feel more?
Something, just something like that, just because somebody could come up and say, what, you don't have the right to do that. You can only say yes or no. And somebody will.
That's like the one from the, kind of reads from the one above it. Okay. All right, we make that in your motion, Fred?
I'm still trying to figure out what my motion's going to be.
I don't even know what it was.
Or you could just say,
I
proposed as
move
staff
we
was.
accept the text amendment, Chapter 2 of the City Code, duties of the Planning Commission, with the,
This is what was for the Historic Planning Commission one, okay. So if you want to add that sentence in there for this reimbursement.
that the, in place of the reimbursement section, that we say that the Planning Commission members may be reimbursed for the actual and necessary expenses
It's not expenses.
and
you're
shall
being-
be compensated in the amount of $50.
No, we don't want to talk about specific fees. Can we just,
We do in the historical part.
oh,
He's reading from there.
I'm reading directly from
oh,
your.
okay, I'm sorry.
That's okay.
There's a zero missing.
I'm just thinking if you get a raise, you don't have to.
Right.
$50 to $600.
For each meeting of the Milton each meeting of the Planning Commission. Period.
Mark's suggestion.
And
Add Mark's suggestion in your motion.
You have to add recommendations.
Making this.
You asked for it, Fred.
and recommendation of changes with making,
The planning commission is allowed to make decisions and recommendations.
and recommendations.
Okay, I got it. I'll translate.
I'll second that.
Thank you.
Okay. Any discussion? All in favor, say aye.
Aye.
Aye. Opposed? All right. Yeah, that's like, I'm done.
I couldn't wait to.
Sure. Next one?
Before you rush through it, Laura wants to speak on the next item.
Okay.
Oh.
You want to present it real first, Kathy?
Yeah,
Or-
Kathy, you want to,
Oh,
for
well,
the
all right,
HPC?
let me present it.
Okay.
Okay, this is on RZ 17-07, text amendment to amend section 64-2453, which is under creation of Historic Preservation Commission, and the purpose of this is to allow compensation for meetings. Currently, the Historic Preservation Commission ordinance states that the HPC cannot receive any compensation. The purpose of this text amendment is to allow the Historic Preservation Commission to receive compensation for attendance at each of their meetings based on direction from the mayor and city council. And this would make the HPC consistent with our other boards and commissions, being the HPC, the BZA, and the Planning Commission, all of which they've already had their ordinances changed to allow for the receipt of stipend. It had not happened with the HPC, so this is sort of a cleanup text amendment, so to speak.
Before we have questions, I guess, I'll get Laura.
Yes.
Public comment. Timer, Robin, click it.
This is fun. Laura Bentley, 2500 Bethany Church Road. And I just wanted to say on public notification, going back, those changes are going to be great. I attended the Ebenezer Road one and the Providence in Bethany, which was, it was awkward at best when staff is there trying to facilitate questions on behalf of a developer. So I think this is totally the right place for the public notification process to be with your background and such. So with regard to compensation, so I know you all have worked for years without compensation and totally agree that is due, and I agree that Planning Commission, the BZA, and the DRB, quasi-judicial committees that are very important, almost critical to our city. I'd just like you to think about some of these other committees that are, different in a sense that people are bringing their talent and their time, and it's not, it's not a set calendar. There's not applicants waiting for a decision. Your meetings go a lot of time well into late hours. So I'm a little bit concerned about the sustainability of compensating all these different committees that, I mean, honestly, I'm on the equestrian committee. I never dreamt that I would be compensated. So I want to bring that to your attention. So just my thoughts on compensating, and is it sustainable, and is it necessary? I mean, I've gotten people to do, volunteer horse shows and make thousands of dollars, and they do it because they love what they do. So just consider that. Thank you.
Thank you.
So let me just make a comment. It'll be the BZA. It's not every board or board that's in the city. It's quasi-legislative. So it's the Planning Commission, BZA, DRB, and HPC, and that's it.
Why is the HPC out of like Parks and Rec? And I mean, why?
Well, because the HPC actually acts as a de facto DRB when it pertains to historic.
have a
Yes, we do. We have a couple of. We have two.
Two properties that have historic designation, and that means before any changes can be made to those properties, the HPC must review and approve those changes and issue what's called a certificate of appropriateness. So they do have, in a lot of cities, for instance, there's an historic district. And that means that any of the structures in the historic district would come under the purview, any changes to the exterior would come under the purview of the HPC. We don't have that at this point. There was some thought at one point to include part of Crabapple and the structures within historic structures within the district. That did not get approved. But there are certainly other things that the HPC can work on, and it is their jurisdiction comes right from the state. There's enabling legislation from the state that really sort of quantifies what their duties are and how far their reach is.
And I think the intent is if and when the HPC is reconfigured, that I think we have a lot of we have other properties that we'd like them to consider to be designated as historic, so that would still apply. So
they can be individual or through a district, either way, and then they have control over it.
Is it an active committee today?
No.
Is it?
we don't have I don't think there's enough people.
No, it
Or new
does not
members.
have a full membership to it.
I think that's one of the goals of the council, correct? One of their, I believe.
open up for a motion.
I move we approve RZ 17-07, the text amendment to amend section 64-2453, the creation of Historic Preservation Commission to allow compensation for meetings.
Second.
All right. Any discussion on the motion? All in favor, say aye.
Aye.
Oppose?
So let me make an announcement. I believe we will not need a April Planning Commission meeting because nothing got deferred and we don't have any new items and the Crabapple plan is going to be pushed, correct?
Right. So let me just give some public announcements, so to speak, on items that affect you all. And it's just as well we don't have an April meeting because we have lots of plans for you. As you know, we had our tree canopy workshop on March 9th, and our consultant now is moving forward with coming up with a draft tree ordinance. So that's moving forward. We've been asked to hold one more public hearing on the Crabapple Downtown Milton placemaking plan. So we have scheduled that for the evening of April 20th here in this room. We have kicked off our UDC, our Unified Development Code initiative, and the first part of the process will be that we'll be holding stakeholder interviews with various groups within the city that would be affected by this UDC, and you all are going to be one of those groups. So Robin will be contacting you to set up a meeting for that purpose. So those things are all underway, and so it'll be a very busy spring and summer. Thank you.
All right. Any other questions for staff?
I got a couple. Just two. One is I wanted to compliment you guys. Thank you for the fact that the stockade went away on Bethany Bend. I appreciate you guys following through on that, where the homeowner had erected the sizable fence. So thank you for seeing that through. Second, I just wanted a quick question for clarification. Peyton and I were whispering at one point about the process tonight. When the applicant, in this case, it was the first case that was before us, had used more than the allotted time, we always reserve the right to extend that time, and it went to about 16 minutes tonight. And then it was intended to be, at least historically, it's been the time for the opposition to express their concerns. And one of the people expressing their opinion during that time was actually in support of that. So our quick discussion was,
In the bylaws, it has public comment. It doesn't say of opposition.
So Mr. Recook indicated to me he wasn't sure whether he was going to
Oh,
speak.
are you serious? Oh.
I apologize, but I think that obviously if there was, we would have added time to the 4
Okay.
and then added it. I know technically it was on that side.
So I guess because when I had the bylaws up, it has applicant and then it has public comment. It doesn't really say opposition so I didn't know if it was the applicant gets his time and then the public comment, whether it be for or against.
Well, traditionally, if you're in support, you kind of
Okay, that's what I-
person
okay.
in support
Okay.
when they
Okay.
in the same pile as the person.
That's
who's
kind of what
the
we,
applicant.
okay.
I wonder if we might want to review that to ensure that we don't bump into that, where somebody says, I have the right to make a public comment because it is in the public comment section as defined by the bylaws, even if they're in opposition. I can see, we haven't ever experienced
No,
it.
when the mayor reads his description of the public comment, he says that each side will have 10 minutes. He actually, and I'm not sure yours says.
Okay, I was just looking, no, that.
Maybe what we need to do is say that right up front,
I
that,
think it says it, but,
say that.
but the bylaws, actually, when I was looking at the bylaws, it has public comment. And so it brings up a point, I don't know if this has happened, but if you're someone who is the applicant, right, and you want your time to rebut, but you have people that are speaking, you just got random people that are speaking, speaking in support of it, they're taking up the applicant's time. So I
think in the past,
know?
what we've done, whether it's that we would just add more time
Okay.
and give it to the other. I mean, I guess
That's always been a default.
Right.
It's a default action that we take. It's not necessarily one that I would suggest that we adopt as a standard practice. It should be an exception to that where there's an extraordinary case, because if everybody's always going to count on us extending, and it's something where we've heard plenty, I don't necessarily think that we should extend.
Yeah, and that's our call, we should.
it's your call, that's right.
Yeah.
You all need to vote on that.
Yep.
I'll show you what I was looking at tomorrow.
okay.
Yeah. All right, well, we're going
Okay.
to address that.
It's just riddled with issues if we are not diligent and we set if we have what appears to be a routine where we always choose to extend, that's dangerous. Yes. We always want to give, the benefit of sunshine on the facts that need to be heard, but I can see in a really contentious situation where that could be potentially abused to our demise and problematic.
Did Walt put for or against on that?
He put for, and I said, because I went around and I said, do you want me to take your card? He goes, well, I'm not sure whether I want to speak or not. And I said, well, let me take the card so I'll have it. Yeah. And so I just,
Okay. All right. That's all I need now.
Thanks. That's all I had. All right. I move we adjourn.
Second.
All right. All in favor, say aye.
Paul.
Aye.
So.
Yeah.